So after talking a lot about the cross-border data transfer, the standard contractual clauses, binding corporate rules and data transfer impact assessment, I am today going to cover a bit important facts about practical implementation of data transfer impact assessment. Welcome to my YouTube channel where you daily see new content on data privacy, and as I mentioned, today in this video we are going to talk about the practical implementation of DTIA or the data transfer impact assessment. What is data transfer impact assessment? A process or a set of documents, guidelines used when you want to transfer your information from European country to a non-European country, broadly an non-adequate country. As per the European laws, GDPR, etc., non-adequate country is the country where the data is not kept safely, in a sense where there are no strict rules around data protection or data safety. So GDPR calls them as non-adequate countries, and let's see how it works for them when it comes to the assessment of that data. The assessment of that process of moving data from a European country to a non-European country is called data transfer impact assessment, and that helps the organizations adhere with the GDPR norms and helps protect the data subjects' rights that are there with respect to the GDPR. In the last video we saw the other countries also do follow some norms, but DTIA as such is more prominently known with GDPR. So we are going to talk about the practical implementations of DTIA norm. As a first step, you should do a pre-transfer identification, pick up a checklist and see whether an assessment is even required or not. Where are you transferring it? You should identify what is the kind of data you are transferring. So it's personal information, then only there is a point to move ahead. Else there is no need to worry about the cross-border data transfer. You should identify the receiving party, country and location and validate if that falls under the list of adequate countries. It may or it may not. When would it not fall under the list of adequate countries? When it itself does not have stringent data privacy laws, right? So then if you are sure that you are sending data to a non-adequate country, you should create a data flow map to visualize what is the data that is moving and where is it actually moving, and then identify if the transfer falls under the scope of data transfer impact assessment. That's something which is very, very important to identify. Engage cross-functional teams. 3 big teams. Legal and compliance. Why? To complete your agreements, to put in the standard contractual clauses, to put in the binding corporate rules into those agreements that get covered under the data transfer impact assessment. Involve your IT and security teams. Why do you want to involve IT and security teams? You want to involve IT and security teams because they are the ones who are going to ensure that the data being transferred is secure. It's encrypted, anonymized, it is safe, there's clear access control. They are the ones who are going to help you identify whether these norms are being followed as per the laws on the destination or as per your discussion with the destination organization where you are transferring the personal information. And of course your data privacy or your data protection officers need to be involved in all this transfer of information, as what we are talking of is about personal information. You should assess the receiving country's data protection laws. You should do a research on what kind of laws they have. Do they follow any strict governance? Is there any enforcement of privacy rights within their own country? Do they take care of their own personal information? And what are the possible or potential vulnerabilities that are there in the destination country or the receiving country that can damage or breach the privacy of your data subjects? Evaluate those safeguards. Ensure that there is encryption. Encryption in transit, very important. Maybe encryption at the start point itself so that encrypted data is transited. And encryption again at rest. Anonymization, pseudonymization. I have a lot of content on the various types of privacy enhancement techniques. I'll tag them here and you can go through that and see what are the various options you have available to enhance privacy for your users. And what are the contractual obligations? You need to create the SCCs and the BCRs. And then there are a few quick final steps. Once you have done all this, once you are sure that you are sending it to a non-adequate country, once you are sure that your legal team has given you the right contracts, your IT team has validated the encryptions and the other data protection techniques, you conduct these final steps. You prepare a risk mitigation plan. What if something goes wrong? How are you going to handle it? deploy any other required additional security measures, monitor the laws of the destination country, how and what laws are being followed in the destination country, and monitor, most important fact, do they even adhere with that? Are they really strict? Are there regular assessments over there? And are their laws anywhere near to your own GDPR compliances? These are the final steps that you should follow, which should end up with proper documentation. All steps, everything, including mitigation plans and the kind of risk that you foresee, should get documented before you start the actual data transfer. So that's about practical implementation of data transfer impact assessment. I hope you like my content. Please press the bell and the like icon. Share your feedback in the comment section and subscribe to my YouTube channel if you have not already done that. Thank you.